Officer Dave, would you open the courtroom for me, please?
The State of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Files on the car. Morning, Counsel.
Good morning, Your Honor. How you doing?
Good. Mr. Carr, we're on the record. This is 21-161-353. Michigan First Rehab versus Progressive Marathon. This is the date and time set for motion to enter default judgment on behalf of plaintiff, and we have a motion to set aside default filed on behalf of the defendant. Could I have your respective appearances?
Joseph Falls on behalf of the plaintiff, Your Honor, P80521.
Robert Carr on behalf of defendant Progressive, Your Honor, P80884.
All right. It doesn't make much sense to hear Mr. Falson's motion before I hear Mr. Carr's motion. Mr. Carr says, don't enter the default. Indeed, set aside the default that was entered when I failed to appear at an agreed upon date and time pretrial. Is that pretty much where we are, Mr. Carr?
Yes, Your Honor.
Your motion, sir.
Your Honor, we're just asking to set aside the default because we made a mistake. We didn't receive the notice to appear. I know we talked about it at the previous pretrial. The date wasn't entered into my calendar. That's why we didn't appear. Complete mistake. Apologize for wasting this court's time. We do intend to defend this motion or this matter. Of course, we've been participating. So just ask this court to give the same mercy to us as they gave to the plaintiff when this happened earlier, and ask to have this case back on.
Mr. Falzon, why shouldn't I treat them the same way I treated you?
I don't believe
Moved on.
I don't believe that defense should be treated any differently than I was treated, Your Honor.
All right. The court is going to find that there's good cause to set aside the default, that setting aside the default will be contingent upon the defendant paying attorney fees in the amount of $250 to plaintiff's counsel within 14 days of today. Mr. Carr, you will prepare the order. The plaintiff's motion to enter default judgment is, of course, denied as moot at this point in time. Now, the bigger question, is this even my case? Remember the last time we were together, or the time before we were last together, we were, standing right on the border of my subject matter jurisdiction ceiling.
And as I was prepared to discuss then, this is your case, Your Honor. He's no longer treating with my clients, okay, and therefore the bill cannot go up. I've instructed my clients that if he walks in and wants to treat and you want to do that, you hold off until I can talk to the judge, because I know we are a hair's breadth away from being over. And I'm not about to put this court through that.
Let me hear from Mr. Carr.
I just want to say, just to clarify, it's a she. Taisha Brown is.
Taisha Brown.
Okay. And I just had a question. Mr. Carr's motion, you indicate that there was a unlawful solicitation, but the deposition that you provided, the transcript, related to a provider other than the plaintiff.
Yes, Your Honor. We believe that.
How is that relevant?
We believe that they're linked, and we can show how they're linked, Your Honor.
Okay, well, it's not an issue for today.
Yes, sir.
So here's what we're going to do. You gentlemen will come back to see me on June 23rd at 10 o'clock. In the meantime, Mr. Carr will prepare the orders denying the motion for default judgment, granting your motion to set aside the default contingent upon payment of the $250 attorney fees to plaintiff within 14 days of today. Now, is there anything else we can accomplish today?
Your Honor, I believe 2 times ago, I had asked if we could conduct discovery in this matter pursuant to 2.309, 310, and 312.
Yeah, we had, as I recall, required you both to comply with 2.3028 very early in the lawsuit. And as part of my understanding of the requirements there, all the bills that an issue should have already been submitted to you.
They were, Your Honor.
And I'm just asking if we can do interrogatories, request to produce, request for admissions.
Why would that not be duplicative of what the information that you already have from 2.3028? That's my question.
I believe that request for admissions would provide us a little more information about what was done with these bills than just giving us the bills. We'd also want to ask certain questions about funding, who is the actual company, and who is the one.
Try it again. Who is the, then I got it.
Oh, sorry. Who is the owner and the providers of the treatment that might not be on the bills and records that were provided. Anything that we can get about what kind of treatment was provided and how it compares to the fee schedule, things like that.
Well, the medical records were sent along with the medical bills, Your Honor. I don't think it's necessary.
Okay, here's what we're going to do. Right now, Mr. Carr, I'm not going to make a decision on that. I'm going to direct you to reevaluate the information that was provided to you under 2.3028. One of the things that I have found is that, now obviously every case is different, but my experience has been when I started requiring the parties to comply with 2.3028 early on, in most PIP cases, that's providing all the information necessary to evaluate and decide my case. I am not interested in providing information related to other cases. So if there's a suspicion that there's some ongoing inappropriate activity going, something like that, that's not relevant in my case. And I would also note, just for the record, it appears that the current Attorney General appears to be interested in the concept of insurance fraud, something that her predecessors, quite frankly, were blind to. So without making a decision, if you want to file a motion and demonstrate some particularized information that you need, and again, related to my case, not something else that's going on somewhere else, I'll be happy to have Mr. Falzon have a response and I'll make a decision. That's what I get paid for.
Thank you.
But my experience has been that we have been able to resolve the PIP cases that are ahead on my docket with the information that is provided by 2.3028. And quite frankly, I don't understand why it was not required in the rule that information be provided in any PIP case, regardless of whether it was filed in the circuit court or in the district court, because the information, the principles of law are all going to be the same anyway. Secondly, I would note that in exchange, in this case, you guys have killed a forest already. So in the time of climate change and global warming, let's save some trees. Now, does June 23rd at 10 o'clock work for everybody?
Yes, Your Honor.
Yes, Your Honor.
Mr. Carr, you're going to submit my orders. Anything else, gentlemen, we can accomplish today?
No, sir.
Just so that is clear, Mr. Carr, I am not saying I will not permit additional discovery. I want to see a particularized need for it beyond the information that is related or was conveyed into 2.3028 and related to my case, not something else. That was one of the things, that was a big flag for me, that you thought is relevant in this case, some claim that this person was solicited by some other provider. That was a problem for me.
Understand, Your Honor.
That's, anyway, June 23rd, 10 o'clock. Gentlemen, we'll talk again. Let's be safe.
Thank you, Your Honor.
Thanks for coming in. We're off the record. Mr.
Judge.
Hill, good
Hi.
morning.
Good morning, Judge.
I've got another case that's going to take some time, but I thought I'd do yours. My problem is I have 3 people here who are listed by phones, and I have no idea who your opponent is. So I'm going to admit them, and then we'll try to figure out what these people are doing here in my waiting room.
Sounds good, Judge.
Come on, man.
Hello? 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 Hello?
Hello.
What is your name, ma'am?
Luella Bass.
All right, you're not, okay, you're here for you're Luella Bass. All right,
Oh, she got the keys.
okay, I see. I'll put you in the waiting room. She's part of my, next-
Yes, you can. She got the keys in her purse.
hello?
Any of the doors will pop open.
Hello?
Then they come in your hand.
Excuse me, ma'am. Cell phone number 313-856-9987. Can you hear us?
Yes.
Who
What's your
are
name?
you?
It's for Arredondo Collins.
Why are you, you're the plaintiff here,
Yes.
Plaintiff, we're
Alright.
the plaintiff.
all right? Then you stay. Now let me find who's at Galaxy A20. I'll put that one back in the waiting room as well. All right, Mr. Hill, let's call your case. This is 22-180-928. The file is entitled Arando Collins versus Greenfield Collision. This is our first pretrial. Your respective appearances.
Ryan Hill on behalf of the defendant, Your Honor. P68445.
All right. And what is your name, ma'am?
Arredondo LaDon Collins.
All right. You are the moving plaintiff in this case. Is it your intention to
Yes.
represent yourself in this matter?
Yeah, unless I need to get a lawyer.
Okay. You have an absolute right, constitutional right to represent yourself. What you do not have is the right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind the attorney, Mr. Hill, will bind you. Do you understand that?
Yes, sir.
All right. So where are we on this file, Mr. Hill? What's this about?
Judge, this is a case where the plaintiffs are making allegations that they brought in a vehicle that had front and rear end damage. Reading their complaint, they indicate that if my client was not to make the repairs, he promised to refund the money. Their position is, I think that the repairs were not made or they were deficiently made, and they made a request for the refund of the $6,000+ and my client declined. Our position is that the repairs were made. They were made in a workmanlike manner. We have video from the shop showing that the repairs were made, and that 3 or 4 weeks later, the plaintiff brought the vehicle back, saying that there was damage or they were done improperly and they want full reimbursement. Those are the 2 arguments, Judge.
Mr. Collins, what do you want to tell the court?
That they definitely didn't do it right. They had nails in my car.
All right. You gentlemen obviously are not in a position to settle the case. So this is what I'm going to do. I had already opened your written discovery in this matter. I will continue your written discovery. And this is our first pretrial. I'll give you another pretrial date. Your next pretrial date will be June 23rd at 11 o'clock. Does that work for everybody?
It works for me, Judge.
What about you, Collins?
Yes, sir.
Okay, June 23rd at 11 o'clock.
Judge, Mr. Collins, is the number that came up on the screen, is that the best number to reach you at?
Yes.
All right,
Okay.
let me stop you both right here. I'm reminding you that we're on YouTube. So when you discuss things like this, everybody in the world literally can see it. So what I'm going to do is I'm going to put you guys in a chat room and you can talk about the case and make sure you have the appropriate contact information. If you settle the case, you're certainly welcome to come back to me. Otherwise, June 23rd at 11 o'clock, the written discovery will continue.
Thank you, Judge.
Thank you for coming in. Let's be safe.
Thank you.
Okay, off to the breakout room. We'll go with you guys. Ryan Hill, assigned to 2. Assigned to 2. Okay. Hello? Hello? Good morning. Let's call your case and let's get started. We are on the record calling case number 21240-852. Luella Bass versus Go-To Guy Property Management. We have motion for summary disposition. Could I have your respective appearances?
Morning, Your Honor. Corey Carpenter, P67818 on behalf of Ms. Bass.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for Go-To Guy Property Management.
All right. This case was initially started by filing of a improper complaint. Then we have a first amended complaint, an answer to that first amended complaint filed on behalf of the parties. In his first amended complaint, Mr. Carpenter alleges retaliatory eviction and breach of contract. So, Ms. Ellison, you believe you're entitled to summary disposition?
That is correct, Your Honor. We had previously came and you ruled on a motion to set aside the dismissal of the primary complaint. You ruled in favor of the defendant. There was no meritorious defense in regards to the retaliatory eviction and breach of contract claim. So we're here just on the counter plaintiff's counter complaint for past due rental charges for the time in which that Ms. Bass occupied the property.
Yeah, you're claiming $1,550. And Mr. Carpenter is pointing out that you got a November 21 abatement notice from the Section 8 people saying that because the property was not in compliance, you're not entitled to get any rent.
So, Your Honor, I did see that and I checked with my client once I received it from Mr. Carpenter. The reason why it went into abatement is because Ms. Bass had a special inspection done for the door not locking. And on the date that they were coming to re-inspect, she was not home. And therefore, that's why it went into abatement, because the tenant was not home. With the tenant not being home, my client is still allowed to collect rent. Moreover, Your Honor, that was also the date. November 1st was the date that her lease had expired and we asked her to vacate the property. And that is, so that was the date that they also came out to do the inspection and when it went into abatement. And even with that being said, Your Honor, even if the abatement issue was true, because there's other forms that were included in that abatement notice that weren't there, that aren't attached to the plaintiff's response of the reason why it fell into abatement. And it was because the Ms. Bass wasn't home. Moreover, Your Honor, the abatement notice clearly states that If she chose to live there outside of the 60 days, she would be responsible for the full rental compliance of the lease. Your Honor, she did move out until April the 8th. So even if it is Your Honor's contention that my client can't collect rent from November and December, my client can absolutely collect rent from January, February, and March up until the day that she moved out. However, I do not agree that it went into abatement because it was an issue with her door that she called the special inspection in for. And therefore, if she's not home, no one can access the building to re-inspect.
But you don't dispute that the abatement notice was issued.
No, I don't dispute that the
All right,
abatement.
so what your argument is that the abatement notice ought not to have been issued. That's what your argument is.
Absolutely, Your Honor. And I
Okay.
have communication with, from the Department, the Housing Commission in regards to why it went into abatement, and I'm happy
I
to.
don't have that in front of me.
Correct, Your
Let
Honor.
me hear from Mr. Carpenter. Ms. Bass,
Your Honor.
excuse me, Ms. Bass, you keep raising your hand. I muted you on purpose. You have an attorney. You will speak through your attorney. Mr. Carpenter, your response.
Your Honor, what I'm hearing is that we have an issue of fact as to damages. I mean, this is a motion for summary disposition. This is the first time hearing about the reason for this abatement. There are other violations on that property, Your Honor, besides just an issue with the door. Defendant could have filed a reply if they had communications and included that, so I could at least review it, but I haven't seen that. This only thing I'm hearing about this is Miss Ellison's representations to the court. That's not evidence. That's a legal argument. So if there's evidence that there was other reasons for this abatement or it shouldn't happen due to my client's fault, which she's disputing, that's issue of fact. And it goes to the issue of damages. I think this motion needs to be denied.
Ms. Ellison,
Your Honor, if I may, the counter plaintiff is in default. You never set aside his default. So therefore, and I did a motion for entry of default. And at our last hearing, you advised me to do a motion for summary disposition. I feel like that motion should have been ruled on in its, as we stood there, because the counter plaintiff is still in default. You never ruled in regards to setting aside his default. So therefore, his argument lacks, he can't present evidence. He can't present anything.
The court's not required to rubber stamp the issue of damages, Your Honor. The court still has to be satisfied that the damages they're seeking are accurate, even if Miss Ellison's arguments are valid. We have an issue
Well,
of fact
first
as
of all,
to damages.
let's stop right here on the question of the default in relationship to the counterclaim. What action did the court enter the default in that regard? What did you do in response to that, Mr. Carpenter?
I find, well, Your Honor never ruled. Your Honor's primary focus was on the motion to reinstate my client's claim against the landlord, which you ruled upon the last time, but you never really issued a ruling as to the motion for entry of default. You just told her to file a motion for summary. But the meritorious defense argument purely last time were in regards to reinstatement of the primary claim. There weren't any arguments really heard as to entry default. Now the defendants already conceded good cause. They did that at the last hearing. Meritorious defense in relation to the counter complaint, Your Honor, is this abatement issue. I think there's an issue of fact here.
All right, this is the ruling of the court. I am not deciding motion for summary disposition today. What I am deciding is that I am going to set aside the default as to the counterclaim. Mr. Carpenter will prepare the order. In relationship to the motion for summary disposition on the counterclaim, Ms. Ellison and Mr. Carpenter will be permitted to supplement their previous pleadings. Ms. Ellison says she has information that should be considered that was clearly not part of her pleading. Mr. Carpenter may feel the same way. So, as I understand the procedural posture of the case, it is as follows. The plaintiff's claim against the defendants has been adjudicated in favor of the defendants. That's water under the bridge. The remaining matter is the claim by the defendant counter plaintiff for damages. That is the motion for summary disposition, which will be heard the next time we're together, giving both of you 2 weeks from today to file any supplemental pleadings that you may wish to file in relationship to the motion for counterclaim. That's the only still living claim in the litigation. Is there anything else we can do today?
Your Honor, I do have a question. In regards to the dismissal of my client's claim, there has not actually been a physical order entered yet. That needs to occur.
Ms. Ellison, you were to enter that order. Did you not do so?
I sent it to the court, Your Honor.
Perhaps you need to send it again. Because I looked on the register of action and I did not see it. And I did not see it in the file.
Not a problem. I can forward it again.
Okay, send that again. So that'll take care of that administrative problem. So what I'm going to do is I'm going to give you guys a June 23rd date for hearing on the counter defendant's motion for summary disposition.
Your Honor, could we possibly do the following week? I'm going to be out of town that week.
Sure. Does that work for you, Ms. Ellison?
That works fine, Your Honor.
That would be June 30th, correct?
That's correct.
And that's at 11?
That's going to be at 11 o'clock. So let's go over again where we are. Ms. Ellison is going to submit apparently again. I'm not going to say I don't have it because my second floor, the order in regard to the motion that I previously decided concerning the plaintiff's case that ended that case. Mr. Carpenter is going to submit an order setting aside the default as to the counter complaint only. Both parties have 2 weeks to supplement the pleadings in regard to the motion for summary disposition in relationship to Ms. Ellison's counterclaim. And we will be together next on June 30th at 11 o'clock. Now, while we're still doing all this, have you guys had a discussion about resolution on the file?
Very little, Your Honor. I will certainly confer with my client, and if there's any resolution that can be had, I will confer with Ms.
Because it
Ellison.
seems to me, now that we know what the maximum amount in dispute is, the party should be able to work something out. Maybe I'm wrong. What can I say? Sometimes I'm right about resolutions, sometimes I'm wrong. So, order from Mr. Carpenter, order from Ms. Ellison, supplemental pleadings if desired from either of you within 14 days. June 30, 11 o'clock, hearing on the motion filed by counter plaintiff for summary disposition. Anything else we can accomplish today?
Nothing from plaintiff, Your Honor.
Nothing from me, Your Honor.
Okay, thank you all for coming in. Let's be
Thank
safe.
you.
Have a good day. Thank you.
Appreciate you.